Now, you know how the previous rule was telling you to be fully devoted to your client? This rule serves as a check and balance to that. Your duty to uphold the law always supersedes the duty to satisfy your client. If the client gives an instruction that would be unlawful, ignore it. But if he insists, withdraw your services. If the instruction involves actions like bribing judicial officers or witnesses, warn your client against such actions. If he insists, terminate your services. Don't give advice to your clients that it's possible to bribe a judge. That's disrespectful to the judge. Also, don't advise the client to disobey any law. Another thing you shouldn't do as a lawyer is to knowingly handle a case where the main purpose of it is to merely harass or intimidate the opposing party. That's an abuse of court process. If you know a claim or defense is unwarranted under existing law, don't waste the court's time by filing such a case. But if in good faith you believe such a case can be backed up by a solid argument, and no judicial interpretation has been given to it yet, then go for it. Rule 15 sub Rule 3D states that you have to inform your clients of the options of ADR, that's Alternative Dispute Resolutions, before considering litigation. If he then insists on litigation, then go for it. Also, as a lawyer, you can't conceal or knowingly fail to disclose what the law requires you to reveal. For example, if you suspect that your client is involved in money laundering, Section 7 of the Money Laundering Prevention and Prohibition Act 2022 requires you to disclose it to the proper authorities. Don't conceal such an information. When you are in court, don't knowingly use perjured or false evidence. That's a crime. In the Criminal Code, perjury is a crime. In the Penal Code, giving false evidence is a crime. Another thing you shouldn't do is that you should not make false statements of law or fact in court. That's deception. Also, don't fabricate evidence to help your client's case. If you know an action is illegal, refrain from advising or assisting your client in doing it. Sub-Rule 4 of this rule says that during the period you are representing your client, if you receive an information that he has committed fraud against another person, court, or tribunal, call on him to rectify it. If he refuses or neglects to rectify the fraud, then you have to report to the affected person, court, or tribunal. But if that information is privileged information disclosed to you by your client, you can't reveal it to the affected person. That would breach Rule 19. However, if the person who committed the fraud is not your client, then you have to reveal the fraud to the affected person. But before you reveal, make sure the client consents to it. Don't just reveal on your own. Finally, Sub-Rule 5 says that as a lawyer, you are not allowed to vouch for the integrity of your client or his witnesses to back up your arguments. The court works with evidence, so if you want to vouch for the integrity of your client, let the evidence you bring speak for themselves. And that's all for Rule 15. In the next rule, we'll be talking about representing your clients competently. Thank you very much for watching, guys, and remember, stay lawful, stay informed.